Welcome everyone. My name is Shane McGee. I'm a partner at S&R Denton, and I'm going to be moderating our esteemed panel this morning. We're going to talk about EULAs, terms of service, codes of conduct, where they belong, what belongs where, and how to make them better, how to make them more enforceable. So with that, I think probably what we want to do is give a little introduction of everyone on the panel. We'll start with Cristina Alejandre, and you want to just talk a little bit about who you are and what you do?
I am Cristina Alejandre. I'm Vice President of Business Development at 38 Studios. We are a video game developer based out of Providence, Rhode Island. Prior to 38 Studios, I was the Director of Licensing and Publishing Support at Turbine, also a creator of MMOs.
Marcus Eikenberry, also known as Marky Dragon online, and I run markydragon.com, which formerly, not anymore, but formerly helped a lot of people do things like bot in game, buy and sell gold, and stuff like that. And at one point was one of the biggest places in the world for buying, selling, and trading World of Warcraft accounts in volumes of around, I don't know, a couple $1 million a year worth of accounts.
I'm Michael Monahan. I'm an attorney at Patterson McAuliffe in Chicago. I do trademark and copyright work, but I also represent developers and publishers in the game space. And by night, I fight crime, except one night a week where I teach at Chicago Kent Law School a course on video game law.
I'm Don McGowan. I work for a company called Pokemon. Before that, I worked for Microsoft Game Studios. And like Mike, I moonlight as a law professor. In my case, it's entertainment law at University of Washington.
Great, thank you. And as we proceed here, if there's a question, please raise your hand. Given that we are blinded by very bright lights, you might also have to holler or throw something at us just to get our attention. But we'll be happy to answer questions as we move forward. Let's jump right into it. We're all painfully aware that the agreements we're talking about, at least 2 out of the 3, the end user license agreement and terms of use or terms of service, are legal agreements. These are legal contracts. So I'll start out by asking Mike, what's, or Don, or anybody, what are the elements of a legal contract such as an end user license agreement or terms of service?
Well, without getting into even more boring stuff than EULAs, contracts are agreements. And so the foundations of which are offer acceptance. I offer, you review and accept. We are now bound by the things that we have, the terms that we've agreed to, and the term of art for that is something called the meeting of the minds. In other words, we've shaken hands or we've signed off on some set of terms between us, but what those terms are, where we have to agree. If we have different ideas or if we have not enough opportunity to identify and understand what the terms of that agreement are, that may affect the enforceability or nature of the agreement between us.
So this meeting of the minds, what types of things can you do to ensure that you have a meeting of the minds that you can put in front of a judge when you're trying to enforce an agreement like that?
Well, one of the best ways to lock in what an agreement is a writing. Things that are written down are fixed, and so you have something to point to as to what those terms are. Now, once you're in the world of a writing, it becomes important. The acceptance of that writing, i.e. signing a contract, or in this case would be clicking through, is a sort of solemn event because you are assenting to what it says in that contract. And by and large, you are held to things that you sign. So if you go to a car dealer or you go to sign up for a credit card or something, a lot of people blow those off, but once they've signed it, if they didn't read it, the onus is, it's shame on them because you're basically deemed to have read what you signed.
Well, let's ask Marcus then, or how many, or let's ask the audience, how many people here on a regular basis read the click wrap agreements, the end user license agreements, the terms of service that are put in front of them when you're downloading the latest version of iTunes or installing a new video game? By a show of hands, how many people regularly read them?
You do not.
They go into my my collection.
That's the round file right next to your desk. Is that the? Yeah. Okay. So just for purposes of capturing this for the video, very few people actually put their hands up there.
One guy, and he was lying.
The other lawyer in the room.
You're trying to maintain that legal fiction for us, right? Marcus, tell me, based on your experience, what, as sort of the, not necessarily consumer advocate, but the person best suited to speak for consumers, do people actually read these agreements?
I would say probably not. And in fact, I would venture to say that maybe they don't even know what the terms stand for. Like in terms of, the terms of service, TOS. Maybe they know that one the most, but the EULA.
What about when they actually do take the time, like the one gentleman here in the audience, to read them? Does the average consumer really understand what they're reading?
Well, I don't fully understand what I'm reading. So, and I've read a lot of them, but there's a lot of legal speak in there that us non-lawyers don't understand.
And Mike or Dawn, these agreements are more or less a take it or leave it proposition, which puts them in the category of contracts of adhesion. How does, and I think that's a term that a lot of people have heard, how does that impact companies' ability to enforce those agreements?
Well, it's a hurdle. A contract of adhesion is, as you said, to take it or leave it, and game contracts or EULAs are certainly one flavor of those, but they come up in other areas. A lot of consumer agreements work this way. The agreement on the back of your parking ticket that says that the parking lot's not responsible if your car bursts into flames, et cetera, is a contract of adhesion. And what makes it that is there's no negotiation, right? You don't go to the parking lot or your credit card offer or any of these other typical consumer relationships and say, yeah, I like what you have to offer, but let's talk about the terms on this page because I think we could maybe change that a little bit, like you might do in a more commercial relationship like a lease or a property sale. So because they are one-sided, one person writes everything in there, and the other person it's a binary exercise. They can take those terms or they can not take those terms. The law generally is built to keep the writer, the drafter, honest. Just because you have all the opportunity to write it, if you want to enforce that, you can't go overboard, right? You can't put into a EULA, for instance, that if you breach it, you owe me liquidated damages of $1 million. I mean, you can write that down, but you're never going to enforce it because basically the courts have said there's got to be a balance against this fairly lopsided contract creation.
Now that said, I mean, they do work. In a previous life, back in the day when dinosaurs roamed the earth, and I was a litigator in Montreal, Canada. I litigated the Dell Terms of Service for the Dell website, and we litigated them right after the Supreme Court of Canada, and they were held as binding against consumers. So these things, you click and you say I accept those terms, like you better mean it. You better like iTunes for the 50,000 times you're going to accept their terms of service.
And as a contract of adhesion, it's not an all or nothing proposition. In other words, if someone is super aggressive in putting together one of these one-sided agreements, they may have unreasonable expectations as to how much they can enforce. They may be kind of being greedy, and so it runs the risk of getting into a contract of adhesion. But that doesn't mean there's just zero contract. That you went too far, and so now you just have nothing. The way to navigate the contract of adhesion problem as a game provider is, even though it's your own universe and you can kind of play God and write what you want, you need to think ahead as to how much do I really need because I don't want to upset the apple cart by being too greedy. And consumers, when you get these long terms of service, you run more and more into the problem of it's kind of unrealistic that your average player or consumer is really reading and digesting all the things they've agreed to.
So is that what we're running up against? Are we running up against as attorneys for the video game companies, judges that are going to look at this, and at some point when things get too complex, too long, too unwieldy, there's going to be this, you're going to lose that sort of expectation that consumers are going to read these agreements and thus be bound to them? And where is that line? How complex do these agreements have to get? How long do they have to get? how one-sided do they have to get before judges stop enforcing it?
Well, they're always going to be one-sided, at least procedurally, right? You're never going to get to a model where, okay, we can't just draft contracts and make them a yes or no question, because you're not going to have a bunch of, say, World of Warcraft players getting their lawyer to call you up and negotiate what their play terms are going to be, right? That's just like credit cards will never do that, parking lots will never do that. And so by necessity, it's going to be a one-sided construct. That said, you have to be your own policeman, and so folks that get fairly giddy, especially since you're talking about a product where you've created a world, and so you're already kind of gone when you make it, and then when it comes time to figure out what the relationship's going to be, it perhaps is intuitive to continue in God mode, but you need someone there to keep you honest. Say you don't want to go overboard because you don't want to disrupt everything. So things like plain language, using fairly common sense terms, keeping things simple and short and broken into bullets, so that even though we have this kind of impression that consumers don't read it, they're assenting to it, and you want to be able to point to it and say, if they didn't read it, it wasn't because it was hard to read. And had they read it, it also did include really shocking things. See, $1 million liquidated damages or something obnoxious. If the terms are both plain and understandable, and for lack of a better word, rational or kind of consistent with the broader relationship. So things like in the terms of service, a lot of codes of conduct that have things like, no, you don't get to use hateful language or spam people or harass people, and if you do, you're going to get kicked out. That's a term that you're not going to have to beg a court to enforce, because everyone is pretty much on board with that. So keeping your, basically being your own governor and keeping yourself within reason, keeping your language more consumer friendly or accessible, go a long way to not running into the problem of, at the end of the day, you're still the only person that wrote it.
But I mean, I'll sort of bounce on that for two things. I mean, frankly, there are two reasons that I can point back to, those of us in the room who are on the game development side. I mean, Christina, how much would you pay a lawyer to write a EULA for you? Like $5?
Probably.
Yes. In my class a couple of years ago, I and Neil Black, who's sitting on the audience, we assigned write a EULA project to kids in our law school class, and we told them, go ahead and cut and paste. That's all anybody does for these things, is cut and paste from other sites. And a part of that is because, as a client, I too would pay like $5 for somebody to write me a EULA, because there are so many of them, it's just cut and paste and assemble them together. So that aspect of behavior on the developer side, where we say, I'm not going to pay you $1,000 to go write an easy-to-read document, because that's my $1,000 that I could have spent on buying better art assets, doing something different, making a different game, making a better game. So the drawback to that is you end up with these things cobbled together from pre-established items, and so there is no incentive for anybody involved in the creation side of the relationship to make them shorter. The second problem that we run into, and you're going to hear a little bit more about this later, I have a pejorative term for it, but there's a non-pejorative term too, is Wikipedia lawyers, right? Wikipedia lawyers and Slashdot lawyers, where you run up against people who say, well, this particular thing that I want to do is not specifically prohibited in your EULA or your terms of service. How was I supposed to know that I wasn't allowed, or you didn't want me to do it? And so what that drives you to on the developer side is to say, okay, if you're going to Wikipedia lawyer me, then I'm going to have to come up with every conceivable scenario, specifically because somebody's going to come to me someday and say, well, that specific thing that I did was not specifically prohibited. How was I supposed to know I couldn't do it? And so that, combined with some frankly asinine things in the law, like all those sections that are required by law to be written in all caps, because allegedly that makes it easier for you to read. There is nothing in the process of creating any of these things that results in, or seems like it's intended to generate, the creation of a document that anybody is going to have any interest to read. And that's just, unfortunately, the nature of how these things come to exist.
Well, let's talk a little bit about what belongs where in terms of the different restrictions and the different types of agreements. Marcus, you said that people don't really understand to some extent the terms of, or they do understand the terms of service, but not the EULA, and they don't understand what stands for what in terms of the legal restrictions. My philosophy on that generally is that the EULA, the End User License Agreement, embodies the restrictions and the licenses needed to operate the client software, the software that you're actually installing on your computer. The terms of service or the terms of use or whatever you want to call them generally apply to the online component of the service, the game, the interactive component of whatever you're agreeing to. And the code of conduct generally is incorporated by reference into one agreement or the other, the EULA or the terms of service, generally the terms of service, and includes those basic rules. Some of the rules you were talking about, you can't grief people, you can't what, actually, in some games that's what you excel at doing there, Mike. But you can't, no cursing, no trying to solicit people's personal information, things like that. So is that let me ask Mike and Dawn first, is that a fair description of how you view those agreements as well?
More or less. One maybe is the same as what you said, but one variation or difference is I sort of treat the EULA as the most formal document, and so even if there's anything that's going to affect the account, right? Whether it's a breach of the licenses and things that are in the EULA, or even if it's a code of conduct, if it's what's going to trigger the ban hammer, then I want it at least incorporated by reference into the EULA because that's sort of the most formal, powerful thing. That said, a lot of this, nobody reads it, and why do we bother, and how can you expect consumers to know things? The opportunities to fix that, even if they're incorporated, are the code of conduct and the terms of service, because my view is, unlike other contracts of adhesion, the parking lot terms, which I imagine one or two of you may look at the back of your parking ticket later today, or the credit card agreement, right? You know your interest rate, but who knows all the other stuff that's in there. Unlike those scenarios, I think consumers in the game space actually are more savvy about what goes on in the EULA, particularly the ones that are kind of on the edge. Why? Because things like codes of conduct, they don't just affect you as the individual player, they're kind of part of your community. So if you're in a game that doesn't allow griefing or is more of a PvE game, then when people figure out ways to grief you, you get pissed off. And you go and look at the code of conduct, you're like, hey, that guy can't do that because the rules say he can't, and I'm going to petition the developers, the publisher, and rat these guys out. And the publisher then is at a decision point of, you know what, we did say that that's not okay, maybe it's foul language or something. And we're going to take action, and usually that action means suspension or killing the account. That is termination of a contract. So one, I think you want to tie them all to the EULA just as kind of the most formal, solemn document, but you want to promote the highlights of your EULA, the things that are important to you vis-a-vis your account holders in these other places, because gamers will be aware of them, and sometimes they're your own policeman.
Let's talk a little bit about the perception of the consumer, of the gamer. And Marcus, Christina, what type of feedback have you gotten, either directly or have you seen indirectly, from consumers, from gamers, relating to these agreements? I mean, are these something that the gamers don't really think about, they're just clicking accept and moving on, or are these something that you hear a lot of grumbles about? What is the consumer impression?
I think that the consumer just clicks and move on. I do disagree a little bit that, they're in game, somebody's doing something wrong, they'll go check the code of conduct. I think the majority of players, when they're in game, know what's right and know what's wrong. They usually just go directly to customer service and petition, and if they are doing something wrong, then likely that person would get booted from the game. We, as video game developers and publishers, are really sensitive to the amount of times you have to actually click through to get into the game. And we found that users literally just click through, and the more click-throughs you have, the more likely we are to lose them. So that's what we found.
Sure, and I don't advocate
it's not that they go back
constant
and look.
clicking through a la iTunes, but my take on it is in things like you have other opportunities to point people to the EULA, not to make them agree to it,
Right.
but to remind them of the more salient points. So on a load screen, selling gold is a violation. If people spam you for gold sales, you're in danger of fraud, that sort of thing. Which one is a good thing to help your community, because people do get into a bad way with the account stealing and some stuff from unsavory folks. And two, reinforces that EULA that you maybe didn't read, there's at least one part of it that I'm reminding you of. And so, again, while players don't know EULA's chapter and verse, if you go to, for instance, by and large, any of these third-party gold seller sites, go to their FAQ, and at the very top is, does this violate the EULA? Is a frequently asked question, and they will say, in my view, foolishly, yes, it does. We drew our best so you won't get caught, but there is a risk. So, does that mean that those players know all the other stuff that EULA? No. Do they know about real money trade and whether it's okay or not? Absolutely, they do.
I also like Mike's idea because it will give your players a way to hate loading screens more. Because they'll at least blame the lawyers for them rather than development time. So there's that too. So that's kind of a bonus right there.
And in a lot of games, they'll have, they will always have some kind of a petition customer service interface. But in many games where they're wrestling with things like botting and RMT, I know of at least two where it's its own streamlined thing where report spam. Right-click report spam. It's that automated. That you put that into the UI to help your players essentially police that part of the EULA. Again, reinforces that this is not okay. And if you later run into somebody where you actually have to go into enforcement mode, for them to say, oh, I didn't read that big long EULA. What are you talking about? It's blasted everywhere that RMT is not okay. Your own FAQ tells people you're breaking the EULA. So they come back and say, yeah, but nobody reads that. Well, somebody read at least that part.
Christina, something you said, that a lot of the business people are sensitive to these additional click-throughs because there's this, it's seen as a hurdle to signing up new players or to get existing players into the game. As attorneys, we're used to having our clients roll their eyes at us when we tell them that they need to do A, B, or C. This is one of the things where I occasionally will roll my eyes back and say, come on, is this one little checkbox, is this one click through, this one next or submit really going to lose you a lot of business? So my question is that really is that legitimate? Is there anything more than anecdotal evidence to prove that one extra step really gets rid of a part of your client base, and if so, how much?
When it was one large document, you and I have had discussions about this, that it's this onerous document, it's not able to be held up in court. Every single time you click on another legal document, you're reminding the player that they're doing all of these adhesion contracts, essentially, right? And so I don't have, specific proof. Our marketing teams at the various companies that I've worked for have done a lot of research on, where we lose people in the acquisition funnel. And where we lose people is at that sign-up stage, and then potentially when you're downloading the game, and then again, you're reminded 3 times, right? Because you're clicking through, the EULA, the terms of service, the code of conduct, and even sometimes the privacy policy. And every single time, you're just reminding them that they are agreeing to all these contracts. I get that it can't all be one ginormous agreement, but I personally too, like if I have to click through and just be reminded about the legal contracts and also the fact that they're not superhuman readable, right. That we found, in the MMO business that, we do lose people. We do.
I can say on this that in our internet marketing and sales, that we do testing on how many clicks it takes to make a purchase or to get into the game. And the more clicks you have a big fall off. And so you need to make it absolutely as simple as possible for them to give you their money. Otherwise, you don't get it. So the more clicks you have, it's really a bad thing. It's got to be as simple as possible. And so you may roll your eyes at needing all that stuff there, but the business people are going to say, well, what's the cost of
right.
putting that there? So it's really, how does this protect us? How does this make us more money?
Mm-hmm. Is there some magic number in terms of clicks or in terms of the time spent going through these agreements or going through whatever other steps they need to pay money? Is there some magic number where the fall off really starts, or is it a general curve?
After about 3, then you start to have a fall off. If you get up to like 10 or something like that, you're lucky to make sales. So if you have just 1 or 2, it's almost like a Richter scale type thing, because the shorter it is, the better it is.
But keep in mind, you have multiple documents, but it's not just the click through of the legal stuff, it's also signing up and putting in stuff for your accounting,
Right.
clicking to download and stuff like that. So it's not just 2 legal documents to click through, it's total clicks. So.
And while I guess it's still technically anecdotal, I'm reminded of when Warhammer Online launched. They, for whatever reason, decided that each time you logged in, they wanted to put up the EULA tile and have you click through. Not just when you downloaded the client and got it started, or not just when that client was patched. I think those are both pretty much must-have EULA events, because when they load the game for the first time, you got to get them on board. And if you make changes to the EULA, say particularly when you download a patch, that's worth refreshing that understanding, because you probably didn't change the terms. But Warhammer, literally, if you logged out, if you disconnected and logged back in, you got the EULA tile. And the forums and the game press were fairly explosive about it. This is ridiculous. This is a big source of annoyance. And yeah, it's just 1 click. I mean, it wasn't, it was the same sort of encounter, but having to do it every time was off-putting and got a lot of backlash from play.
Yeah, if you get a lawyer that recommends that you do that, you should fire them and hire Mike or Shane.
I also want to say, when you patch and the agreements come up again, how are we supposed to know what line was changed in it? Because I've looked at these plenty of times, and there's nothing highlighted saying this was changed. There's nothing like that.
Sometimes there is no change.
Well, then why am I agreeing to the same thing again?
Because I actually can answer that, because there's a federal law that says if you're going to download software into people's computers, you have to give them the opportunity to say no to that.
Yeah, well, we don't have the opportunity to say no if we want to play the game.
Yeah, fair point.
Yeah.
I didn't write it well.
Well, and it's easy. The terms that have changed were the ones you didn't read the first time. So,
As if I can remember those 30 pages.
We have an actual question from the audience.
I just wanted to make a note that, like, for example, Apple, iTunes, all those, every time you click on that updated end-user license agreement, they actually do bullet point at the top of the end-user license agreement what's changed.
So that was celebrity attorney Neil Black fishing for business from Apple. They actually bullet point the changes.
And I would say that's actually really good practice. You put it right in front of people when they're clicking a bullet point list of, here's what's changed in a section reference, and then they can dig down and find where that is.
I think that can be a great practice if it's done correctly.
I'd be a lot more willing to read it.
I also come back to when you have things that are changes that are not just reinstating the EULA because of the sort of federal software stuff. Again, take advantage of your other communication channels, your forums, your dev blog, things where if it's a meaningful change where you're changing something that is not just just forum selection or technical lawyery stuff, but if you're changing more material terms or codes of conduct, or if you're changing your approach on user-generated content, right? You were a game that didn't allow modding, and now you want to go forward with modding. Well, you're going to change your EULA to address that or have a separate one. But also take advantage of settings where you can use plainer language, or where you can have more confidence that people are reading it, as again, like a dev blog or a forum community.
Don't you risk at that point having terms that could be construed as conflicting, the plain language version that you're communicating to your user base through these other channels, and then in the EULA or the terms of service, the more legalistic, actually binding language, and couldn't people use that against you in litigation?
I don't think so, because I think it's sort of no more risk of inconsistency than, say, the bulleted executive summary. And in any of those communications, like a dev blog or in your forum community, it would be, here are some things that are different. For more detail, or to learn more, here's a link to the actual EULA, and you can read all the stuff you want to. So you're constantly steering back to the controlling document is this big monster, but you're taking opportunities to broadcast the important things.
And I think that's the important point, is you're sending people back to the controlling document, and that's something Neil said too. you're telling people what changed. You're not exactly telling them how it changed. You're telling them what changed and say this is the section you need to refer to in the EULA.
Right.
Okay. Yeah. So Christina, are these in the development process? Where do video game developers actually start thinking about these agreements? When do they get the lawyers involved, and is that different from when they should get the lawyers involved?
I think the developers would always not rather have lawyers involved, but you know, when we develop our game, we just hope to provide the best experience possible for the customer. I think that from a development standpoint on the business side, we want to just maintain the best and healthiest community, and so we don't create the game around the EULA. We just hope that the EULA and the privacy policies and terms of service and all that actually just protect the actual game that we're developing.
Mike, what's your experience in terms of when have you been involved, and when is it easier and more productive for you to become involved?
Well, earlier is better because for some of the more mundane reasons, you know, you don't want to be rushed into putting together an agreement for a game that's on the eve of launch, and you don't want to, just like anything, you don't want to rush it. But I also, to kind of echo on the community idea, I really do kind of genuinely believe that the EULA, as boring a thing as it is, and especially the terms of service and the things that are kind of ancillary to it, they are a building block to your community. And what I mean by that is, particularly on things about conduct, you know, there are certain kind of game design decisions that will change how you will approach the EULA. So for instance, a PvE theme park game may have a fairly strict code of conduct because by and large the player experiences vis-a-vis the game world, and so you may want a more controlled environment with kind of stricter guidelines or stricter limits on things like language and chat and whatnot, and griefing. In a sandbox game that's more PvP centric, then you have to take a bit of a different approach, and that players are going to be in conflict because that's part of your game. And so things that might be griefing in a theme park game, you know, repeated player kills or something, that's probably a-okay in your sandbox game because that's a design decision that you've made. Another thing is, you know, in-game chicanery or scamming, dare I say. That may be, if your game world is a mercantile, sort of cynical setting, that may be appropriate. And so your terms of service, or EULA, or wherever you put it, may say, buyer beware. You know, scamming and deception and spying are legitimate forms of gameplay, so don't come crying to me when that happens. On the other hand, if yours is a theme park game, or maybe a game for kids or something where that's not appropriate, then you're going to kind of go the other way on that. And those may be the sorts of things that get you in trouble. So there you have kind of two very different code of conduct, terms of service provisions that are driven almost entirely by what sort of game are you making. And so identifying and kind of working through that early is a lot easier to do.
So Dawn, you're going to have a very, I think, unique perspective on this because you wear two hats. You're wearing, you know, the business hat that Christina's wearing and the attorney hat that Mike's wearing. So what's your perspective on this?
Well, I mean, what I find kind of, you know, and I will readily admit I have not fully got my head around this particular thing is we're sitting here talking about, okay, well, you need a EULA, you need this, you need that. But they don't exist in console games, right? Has anybody accepted a EULA for any game they've played on their Wii or DS or Xbox 360 or anything? There's no EULAs on these games really to speak of. There's some of them have them in the manual, and I readily admit I haven't thought my way through this, but when you get the exact same game on the PC, right? Insert game, cross-platform game title here. On the PC, it has a 15-screen EULA, and on the console, it's got nothing. And you know, it's sort of, it does give the, you know, give the business hat of me, you know, cause for pause of like, well, is the lawyer hat of me either overly protective on the console or on the PC side, or underprotective on the console side? And I don't fully know the answer to that. But it's something that, you know, I think those of us in the business have to think our way through. So that's sort of point number one. Point number two is, you know, yes, Christina could not be more right about the idea that, you know, this is, you do not want to send the very first message to your customer to be, listen, we are a fun game. Trust me, is this not an awesome contract we are giving you the opportunity to read? Do you not think that the whole game will be fun just from reading this contract? And so you have to sort of balance that off when you're doing development work and when you're working on a project that you would like people to exchange money in consideration for.
Yes, sir.
Shane, back to a comment that Mike made, and I think it's really important that if you're talking about a game that's a tween game, for which COPPA is going to apply, I can tell you from personal experience, 2 separate clients came to me. The one that came late and had COPPA compliance issue cost 10 times as much as legal fees as the one who came early to me. If you're dealing with COPPA, you've got to get, if you've got a game that's going to have kids under 13 in it, you got to get the lawyers in really early, or you're going to pay the piper. I mean, Playdom just got nicked for $1.3 million by the FTC. Just something you can't play around with. If you're doing a youth-oriented game, you got to get the lawyer in early.
I couldn't agree more, and just for purposes of getting that on video with a microphone, the comment was that it's a lot less expensive when you get attorneys involved earlier, especially when you're dealing with these tween games that involve COPPA compliance.
Well, I think another example for a game, or at least a virtual world that is even kid-focused, if you look at Linden. I mean, Linden's problems with the Bragg lawsuit were driven largely, and other problems that it's had in the press, is driven largely by, they started with a more laissez-faire approach to their end user, and then over time realized, well, we said you could do everything, but you know what, maybe it's not a good idea to have casinos. So now we're going to change it to that. And then later, maybe it's not such a good idea to let people run banks. And so because they kept having to double back over what that relationship was going to be, I'm not close enough to it to give any sort of figures, but I think 10 will get you one, that cost them a whole lot more than focusing on their EULA up front.
It looks like we only have a couple minutes left. I was going to get into enforcement, but it doesn't make sense to really start that and we try to finish in a minute and a half. Does anybody have any other questions that we can answer based on what we've already covered? Sir.
What about international jurisdiction and localization of EULAs? Was there a good resource for that?
International jurisdiction and how you deal with that in the EULAs, whether you have localized EULAs. Who wants to comment on that?
It's expensive. I have no real good answer for it. When you have something that you're looking to deploy worldwide or in significantly large numbers of countries, you will immediately run up against European law provisions and especially safe harbor issues, right? Where you'll have to consider data storage issues almost immediately, and that creates a significant, I would almost call it a logarithmic increase in your bills.
Privacy.
Yeah.
Probably once you're going, once you're out of U.S. North America, frankly, just out of the U.S., privacy becomes a much bigger deal, and it's one where, that's more expensive and more cumbersome because you've now got to be right in a bunch of different places.
And I'll just say I've seen clients take one of 2 big choices there, or 2 big options. They've some that don't have the resources to go through this, country by country analysis, and it does get incredibly expensive. Will sometimes just focus purely on the United States and put something in their agreements to say, if you're accessing this game from outside the United States, you're doing so at your own risk, and you understand that we're complying with U.S. law and nothing else. Now, how effective that is from a legal perspective, big question. But I do see game companies going that route more and more, just because complying with the laws of every country where they have a consumer or a customer or player is virtually impossible. And the second group are the people that do it right, and they will get international counsel or work with counsel in every one of the countries where they have a significant amount of players and make sure that their agreements are consistent.
Just to sort of round that up, if you are looking to lock your customer base in so that you're only taking customers from the United States, and the easiest way to do that, frankly, is technologically, which is when you do account creation, you force a field, you just code the zip code field so that it only takes 5-digit number zip codes, because the only country in the world that has that is the United States. So you effectively force people either to lie to you by saying they're in the United States, or they can't enter their address and they can't create an account.
Yes, sir.
Are there, I was curious if the panel has any game companies in mind that they think are doing a particularly good job on EULAs. I don't know if that's a question that makes sense, but I know I've encountered a couple of EULAs that look like they were designed to be written in plain English, other ones that are written in not plain English. Is there anybody that you think is doing a good job?
Christina. I'm not just saying that because she's right here. I'm saying that because she will hit me if I don't.
I work for 38 Studios. We are developing an MMO. We will be developing a EULA, terms of service privacy policy. Our goal in that, and we haven't done it yet, but we hope to be spectacular at it. But our goal in that is to make it as human readable as possible, and not be onerous, and still protect our company and still protect the other players that might be affected by any malicious actions, but also make sure that the player feels empowered. It's going to be, an interesting balance, but that's what we really hope to do. Just, given the steps forward in technology that have been happening, the digital age and all that, we hope to find a good attorney somewhere, maybe one on this panel, that will help us. Get through that. But we and I'm not trying to sound pitchy for 38, but we really want to value the customer and their experience and value their time and money, and human readable is important to us.
Let me ask the audience, what EULAs in terms of service have you seen that you find better, easier to read, fairer than the others?
Can we go back to the point that only one guy acknowledged reading them?
Version 83 of iTunes is much better than version 87 and version 128.
So it gets worse as time goes on for iTunes. You say, okay. Anyone else? Well, are there any of these agreements out there? I mean, we've been involved. Mike and I and Don as well have been involved in drafting a lot of these agreements. So I'm curious as to which ones you appreciate as the gamers. None. Okay. Wow.
They're all horrible.
They're all horrible. All right. Unfortunately, there has to be some horribleness, for lack of a better word, in those agreements to preserve the rights of the gaming company. It's a very difficult thing, speaking as a lawyer, to balance, protecting your client, which is what you're being paid to do, with making it readable and understandable. But it's a balance that I know Mike and I both try very hard to strike.
I see hands in the back of the room. We have probably bumped up on time. And so I just want to because they're tight for time here at Login. So why don't we wrap and then we can stay and talk to people afterwards if they would like to.
Yeah, we'll make ourselves available. Thank you again to the panel. I really appreciate you all coming in and doing this, and thank you everyone for coming.